Good afternoon, everyone. Welcome to the Assembly Committee on Commerce and Labor. Madam Secretary, please call the roll.
Assemblywoman Carlton.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Dickman.
Here.
Assemblywoman Duran.
Here.
Assemblyman Flores.
Present.
Assemblyman Frierson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Martinez. Assemblywoman Marzola.
Here.
Assemblyman O'Neill.
Here.
Assemblywoman Tolles.
Here.
Chair Howdigi.
Here. Thank you, Madam Secretary. Please note that all committee members are present. And before we get started, I would like to go over our normal housekeeping. Please remember all exhibits, written testimony, and amendments must be submitted by noon, the business day before the committee meeting. People who wish to provide testimony or attend the meeting virtually must pre-register online at the legislature's website. And the public is strongly encouraged to submit written testimony in advance of the meeting. Members, please remember to keep your camera on at all times. This will help us ensure we have a quorum at all times, unless you are stepping away for non-committee related business. Members, presenters, those who are here to testify, please remember to remain muted at all times. If you are speaking, unmute yourself and then please promptly mute yourself when you are done. Thank you, everyone. On today's agenda, we have two bills that we will be hearing. I will be taking these in order, and the first bill on our agenda is Assembly Bill 61. So I will open the hearing on Assembly Bill 61, and I believe I have with us our Attorney General, Aaron Ford, and Mr. Mark Kruger to present. Attorney General Ford, are you on with us?
I am. Hello, Chair Howdigi. Great to see you, and thank you so much. And hello to the committee. I am Aaron Ford, your Attorney General. I'm sitting in my conference room across the street from you with my mask on. I have my second assistant, Christine Jones-Brady, with hers on as well. We are separated out, so I'm going to take my mask off to talk for now, but I wanted to start it off with that acknowledgement first. But also acknowledge, as you've indicated, that I have two of my other colleagues as well, Mark Kruger, who is our Chief Deputy Attorney General, and our consumer advocate, Ernest Figueroa, who assist us in presenting this bill to you. So again, Madam Chair, members of the committee, consumer protection has been an important and defining arm of my administration as Nevada's Attorney General. The protection of consumers in Nevada, including residents and businesses from unfair and fraudulent acts, is one of my what we call 5 C's in this office. And I will just briefly tell you what they are. The first C is in fact consumer protection, ensuring that we focus on protecting consumers. But I've also talked about 4 other C's: the protection of constitutional and civil rights, criminal justice and reform issues, community engagement and involvement, and client services, which includes constituent services. And so I want to present this bill personally as one of the examples of the 5 C's that we operate in this instance, specifically in the consumer protection context. What I intend to do is give brief opening remarks and then turn it over to my colleagues to be able to explain the bill section by section and entertain questions. With the chair's indulgence, if I need to exit after that, I would ask for permission to do so, but I'm right next door and I'm able to come back to answer any questions that the committee may have specifically for me, although I do believe you'll be in great hands with my colleagues here.
Absolutely, General Ford.
Thank you so much. So I'll begin now talking about AB 61. AB 61 intends to give the Attorney General's Bureau of Consumer Protection the modern day tools it needs to enforce unfair and deceptive conduct in this state through enforcement of Nevada's Deceptive Trade Practice Act and other consumer protection statutes against today's modern day fraudsters. AB 61 seeks to establish a price gouging prohibition during the times of the governor's declared state of emergency. as we've discovered during this pandemic, such a provision is necessary to ensure the price, for example, of toilet paper and disinfectants and to ensure that they remain reasonable during an emergency and that fraudsters don't take advantage of residents who are already hardest hit when they've lost their jobs. As an anecdote, I will say that we've received maybe not hundreds, but certainly dozens of complaints on the price gouging in the price gouging arena from every community that you could consider. But we got a lot from our minority communities, oftentimes where there are food deserts because there aren't sufficient grocery stores there. And those that are there sometimes are hit by a supply chain concern that has artificially raised prices beyond what is reasonable. We do believe, obviously, that needs and necessities can operate and exist at the exact same time. For example, a food desert means that you don't have enough grocery stores there. But we also have to ensure that those who are there can afford the food that is being provided at those grocery stores, and at the same time protect businesses from unscrupulous actions that fall within the price gouging arena as well. In this arena, I know that we're going to be getting some opposition testimony to the current iteration of the bill, and we welcome that as an opportunity to continue talking with our small businesses about this, because frankly, some of the same small businesses and their consumers reached out to us during the pandemic to likewise complain about price gouging. So it's a real issue, and we look forward to working with them as well as with committee members to ensure that we can allay and assuage any concerns that you may have in this arena. AB 61 also seeks to harmonize criminal penalties with that of general fraud. It would, in fact, increase penalties for robocalling as well, which has become the #1 complaint to the Federal Trade Commission across the nation and here in Nevada. I've had numerous robocalls, and I find them to be annoying and deplorable, and we need these revisions to help continue the fight to stop these annoying calls. AB 61 also seeks to take advantage of the good work that you as a body did last year in changing online protection of consumer personal identifiable information by making a violation of certain provisions of Nevada's security and privacy laws under NRS Chapter 603A, a violation of the Deceptive Trade Practices Act. In addition, to make it easier for our Consumer Protection Division to ferret out companies and people who would commit these fraudulent acts upon our residents, AB 61 eliminates the statute of limitations for violations of the DTPA. It revises provisions for the conduct of administrative hearings, as well as enforcement of orders for the collection of restitution for those that have been harmed. And it allows our BCP to retrieve discovery documents and data from state agencies in support of state litigation. Again, I recognize that that's going to raise the eyebrow, at least in terms of the criminal penalties of many members of this committee, because you, like I, are associated with current efforts at criminal justice reform. Rest assured, I remain committed to criminal justice reform and ensuring that we do not overly criminalize things. That said, please understand that with me presenting this to you, hopefully it's with a little bit of credibility to let you know that I have a team here who is looking to do the best that it can to ensure that our residents are protected, even within the confines of criminal justice reform. Again, we remain confident that we can have conversations with you and others around these provisions to ensure that we can have a properly tailored bill at the end of the day. Finally, AB 61 makes amendments to ensure greater punishments for those who would harm our seniors and vulnerable persons, as well as our youth. And it also provides a general cleanup amendments as well. So thank you again for your consideration of AB 61. My team and I are here for questions. And to go through the bill section by section, I have with me again Mark Kruger, who is one of my chief deputies, as well as Ernest Figueroa, and as well as my second assistant, Christine Jones-Brady, who I don't believe will be speaking unless she decides to. But she is also one of those who oversees this practice. And I'm sorry, you said something else? Okay, very good. So with that, Madam Chair, unless there are preliminary questions, I will turn it over to Mr. Kruger.
Let's go to Mr. Kruger, and then we'll take questions after the presentation. Thank you for joining us and for being here.
Good afternoon, Madam Chair and members of the committee. I'm Mark Kruger, Chief Deputy Attorney General of the Nevada Attorney General's Office. General Ford asked me to take you through the bill as presented. So I'll start with section 1, which is a provision under Chapter 597 to increase penalties for robocalling. And when you have any questions, we can go into more detail. I'll just keep it brief. Section 2 adds sections 3 and 4. Section 3 is the price gouging prohibition that General Ford just discussed. And then section 5 increases or actually creates a violation of Chapter 598 for violations of federal legislation prohibiting robocalls. So section 1 and 5 kind of work hand in hand. Section 6 actually adds section 7 through 17. Section 7 provides a provision that covers what has been very absent from our Chapter 598, which is really unfair things or unconscionable acts. Section 8 then basically ensures violations of the act are also violations of Chapter 598A, which is our Unfair Trade Practices Act, since a lot of times we find that these two chapters work in tandem. Section 9 maintains consistency of the bill with established exemptions, as well as Section 10 and Section 11. Section 12 actually ensures that the Attorney General's office has co-enforcement authority for civil administrative actions, both with Consumer Affairs Division. And Section 13 actually increases, it actually increases penalties against minors, ensuring that it is consistent with penalties when you have crimes against elders or persons with disabilities. Section 14 maintains consistency with the bill and with established enforcement actions, as well as Section 15 and 16. Section 17 is the part General Ford talked about that we seek to harmonize criminal violations in Chapter 598 with those of general fraud, specifically theft. Section 18 actually amends Chapter 603A or includes Chapter 603A violations, which is the privacy data violations as a violation of Chapter 598. Sections 19 through 20 Section 18 includes 19 and 20, which do the privacy piece. Sections 21 through 24 also maintain consistency of the bill with the enforcement provisions. Sections 25 and 26 amend Chapter 11, which deals with the statute of limitations for Chapter 598. Section 27 amends NRS 41 to maintain consistency with the bill as well. Sections 28 through 30 amend Chapter 171 for consistency of the bill for purposes of criminal enforcement. And again, remember that harmonizes the criminal penalties in 598 with that of general fraud. Section 31 allows the Attorney General in our litigation cases primarily to get access to state records that are actually in the possession of other agency boards or commissions. Section 32 through 35 are, again, amendments for consistency of the bill. And Section 36 actually attempts to correct an error that was created when prior sessions, the Consumer Affairs Division was defunded. And then when it received funding again, this particular oversight provision wasn't given back to them, and this would do that. That is a brief summary of all of the sections of the bill, and I'm happy to answer any questions on behalf of the Attorney General's office.
Thank you, Mr. Kruger. I am going to turn to the committee to start to see if the committee has any questions. Assemblymember Tolles.
Thank you so much, Chair, and thank you, Attorney General, for the presentation, and Mr. Kruger for the step-by-step. It's quite an extensive bill, so I have a couple questions, and I may just come back to more, but just want to, specifically, in general, I just want to clarify. So when we're talking about a state of emergency, and I saw in the amendment that you did narrow that down to the area of the direct emergency, but in, let's see, section 3, subsection 4, that it's for the emergency or disaster area. And I was just kind of as a bigger backdrop question, we're obviously in a state where we're going on 12 months or so of a declared emergency that would encompass our entire state. So is it the intention of this legislation to apply this to all circumstances across the state in, such a time that we find ourselves in currently?
Thank you, Assemblywoman Toles. Madam Chair, do I speak directly to her or do I go through you?
Directly to the member, please.
Thank you so much. Assemblywoman Toles, I think I understand your question is asking whether this would apply. Well, let me answer the question I think you've asked. Yes, it would apply to wherever the emergency has been declared. So in the circumstance here where we have a statewide emergency because of the pandemic, where we see price gouging taking place, whether it be in Elko or whether it be down in Enterprise, Nevada, yes, the amendments would in fact change there. I mean, would apply there. To the extent, for example, there's an emergency that's a lot shorter. We've seen those before, where you have an earthquake or you have a flood and there's a 3 or 4 day emergency that has been called. It would apply there relative to the place and time frame for which that emergency has been declared.
Okay, thank you for that clarification. And if I jump ahead to section 17, down to subsection 3, and that's on page 12 if you have the original bill in front of you. I noticed that we have for an offense involving a loss of property or services valued at $1,200 or more, but less than $5,000. It bumps up from a misdemeanor to a category D felony. So if I remember correctly from my judiciary days, we've jumped from misdemeanor past gross misdemeanor to cat D felony. And then it graduates up from there based on the value of the property loss. One just clarifying question: what happens if the value is under $1,200? Is that go away? There's no misdemeanor. So let me stop with that question.
No, go ahead. I see Mr. Kruger has unmuted himself. I'll allow him to chime in here.
Okay, thank you. Assemblywoman Toles, thanks for the question. Mark Kruger for the record. The intent of the edits were to mirror the punishments that can be found in specifically theft. And so that's where the categories got set for. So to answer your specific question, the gross misdemeanor would still be in place. This just sets the price limits that you would see for theft and harmonizes them with this particular chapter.
Okay, thank you. Thank you. And
Follow up, Assemblymember Toles, because I do have members with other questions as well.
thank you, Chair Huddy. I'll pause for now, and I appreciate the indulgence of the 2 questions. Thank you.
Yeah, absolutely. I think I have a member who has a question on this section as well. So let me go to Assemblymember Flores.
Thank you, Madam Chair. And thank you for starting the conversation there, Assemblywoman Toles. Just because I had some questions about this. I appreciate what you just indicated. I guess what I wanted a clarification on is, I'm thinking of those folk who are going around house to house or targeting specific folk or certain areas, and let's say they're cheating families out I don't know, $800, $900. They're quick little hustles, and I see that happen, right? So I'm curious to know if those individuals now with this change in language are somehow going to be flying under the radar when we're continuously finding that same individual engaged in the same type of conduct. Because as the section is written now, my understanding is we were capturing that individual, right? We got him for a second time. Now we're going to hit him with a harsher punishment. We caught him for a third time. We're going to hit him with a harsher punishment. So I'm curious to know if we implement this language by removing that first, second, third, and increasing the punishment will an individual who is consistently committing the same crime not be penalized in a more severe manner as they're caught a second, third, or subsequent time after that?
So I'm going to, Aaron Ford, for the record, chime in real quickly here, or briefly, and allow Mr. Kruger to speak a little bit. I want to offer a little background on the purposes of incorporating these types of things. As a general matter, BCP, the Bureau of Consumer Protection, has jurisdiction under 598, and oftentimes there are violations of fraud and theft that are not contained within 598, but they can nonetheless be pursued under a particular cause of action. And so instead of having to rely upon the generic fraud statutes, we intend to here incorporate those exact same things into the BCP jurisdiction under the exact same rules and requirements that currently exist. So this wouldn't be changing, and I want Mr. Kruger to chime in here, this wouldn't be changing what you've already done relative to the allocation of punishment for first, second, third time offenders, nor would it be changing the circumstances under which they can be charged. It would just enable BCP to streamline its prosecutorial processes and abilities by incorporating those directly within our jurisdiction. So I don't know, Senator Flores, if that completely answers your question, but I think it addresses it at some level so that you can understand we're not attempting to add new crimes or penalties. We're simply looking to align the statutes so that BCP can do its job a lot more efficiently. And if I'm incorrect in any of that, I'm certain that my boss, Mr. Kruger, is going to let me know right now.
Assemblyman Flores, Mark Kruger for the record. No, General Fort's absolutely correct. And I, from what I got from your question, I would like to add that this would actually enable us to, within the Bureau of Consumer Protection, get to those types of crimes, exactly what you were talking about, and actually help more people.
Thank you.
Thank you, Assemblymember Flores. And I just have a quick question to General Ford in this section. So why are we aligning it? What wasn't working about the way this statute was currently written as a misdemeanor, gross misdemeanor in category D, that we want to change it and align it with the other statute? Because we're going to a category D, category C, and category B felony now.
Mr. Kruger, go ahead.
Oh, thank you. General Ford and Madam Chair, Mark Kruger for the record. The problem that we were running into is that the misdemeanor was really our only ability to move forward. But we were getting people who, and I'll give you a specific example. We had a guitar consignment company who literally stole guitars, for lack of a better way of saying it. And we ended up taking a civil action against this person and recovered a judgment against them for $22,000 for the restitution for these people's guitars. It would have been an opportunity for us to also have been able to take an action criminally against them, to have some teeth behind it, to actually get the restitution, especially with Marcy's Law now, and having that restitution paid back. A little aside to this case, we learned that later that he had hidden some of the guitars in a storage shed, and we never were able to recover them. And we're still trying to pursue a second judgment to enforce the first judgment to try to collect this money. And the individuals absconded to Oregon last we found out. So with the misdemeanor being the only charge we could start with, it wouldn't have given us the tools we needed to get restitution for these people that were victims.
Thank you, Mr. Kruger. Okay, I'm going to jump to Assemblymember Dickman.
Thank you so much, Madam Chair. I was just wondering why you brought a deceptive trade practices bill as opposed to a price gouging bill. There's some difference in prosecution, or?
A couple of responses, Aaron Ford for the record, and I will allow obviously Mr. Kruger to chime in as well. Ms. Dickman, one of the things that we found during this COVID crisis was that we didn't have a standalone price gouging bill. And so we had to get somewhat creative in order to be able to protect consumers during this time period, and had to rely upon antitrust laws, for example, or a look at other general fraud statutes. It makes it more difficult for us to be able to protect consumers during times like these. Our jurisdiction in the BCP is prescribed by statute, and one of those statutory jurisdictions is the Deceptive Trade Practices Act. So that's why we're bringing a price gouging bill in the context of our jurisdiction, but also within the context specifically for emergencies that have been declared.
Thank you so much. And Madam Chair, could I ask sort of a follow-up?
Yes, Assemblymember Dickman, please.
Thank you. In Section 7, 2B, it seems kind of broad, the word or the phrase unconscionable practice, and it's defined a little bit, but could you maybe give an example?
We can, Mr. Kruger.
General Ford, thank you. Assemblywoman Dickman. The reason for the unconscionable language, as I said earlier, is that we have a Deceptive and Unfair Trade Practices Act. And the problem is we don't have language in there that really gets to the heart of what is unfair. And unconscionable is meant to do that. And so I'll give you a couple of examples. One of the areas is notarial fraud. And along with that is these individuals who would take advantage of people who maybe don't have English as a native language, and they would use an English contract and then put in their terms that this person might not necessarily know. It's really an unconscionable practice. Another example, it would be in areas where people might want to profile and set different prices based upon things such as sex, race, sexuality, gender, things like that. So these are the types of things that we know we see, but we don't know how to describe, and that don't necessarily fit under the other enforcement provisions of Chapter 598. The need for it is important, and other states have similar statutes. So I can give some additional examples if you need them, but I hope that answers your question.
Yeah, and if I could, Aaron Ford, to follow up real quickly, the great example he's provided is notarial fraud, where a lot of immigrant communities are taken advantage of in this arena because, as he's indicated, it's a language barrier oftentimes where people can be tricked into thinking they're getting something that they're not. And, it doesn't necessarily mean that they've been coerced or that they've operated under duress or that they've been intimidated in a transaction, but what they have done is absolutely unconscionable. And by the way, unconscionability is a prevalent term of art in the law, such that it's, again, not making up a brand new standard. You can always rely upon how it's been interpreted in the law, through case law, and otherwise in order to ensure that this isn't something that's overbroad or overreaching. Hopefully that helps.
Yeah, appreciate that. Thank you.
Okay, next I will go to Assemblymember Kasama.
Thank you, Chair, and thank you, Attorney General and Mark Kruger for the presentation. My question has to do with, again, the Section 1 creating a Category C felony. So the way I understand this, if somebody, even on their first time, were to make a robocall it could be for political reasons, it could be for selling goods, it could be for real estate, there could be a lot of different areas. And to immediately go to a Category C seems to be too harsh, in that I sit on the Judiciary Committee and I hear a lot of, we have too many people in the jails, we've criminalized too many penalties, and we need to figure out ways to not be putting so many people in the jail. And at a Category C, you're looking at automatically 1 to 5 years. I, too, am bothered by robocalls. I don't think anybody enjoys them. But I think that would overcrowd our system. It's already overcrowded. I think habitual users, I also recognize that there are certain businesses that will consider this just a cost of business, and they'll pay the penalties. And I think that's what you're addressing here, is that we have these people that just pay the penalty and you don't have any teeth to stop it. I think it would make more sense to have it be on a graduated level, so that a first-time offender is not put in jail for making a phone call. We don't like it, but I think that is too harsh. And so I think rather it should be some type of a scale, so that we don't overcrowd our prison system, our jails. And I would hope that that would be something that could be perhaps considered. And thank you for your time and for the comments, and I yield. Thank you, Chair.
Thank you, Aaron. For the record, Senator Kasama, I don't think I've been given the opportunity to say congratulations to you on your wins, so congratulations to you. I do want to allow Mr. Kruger to chime in first, and then I have a follow-up comment, I'm sure. Go ahead, Mr. Kruger.
Thank you, sir.
Thank you, Assemblyman Consama. This is Mark Kruger for the record. We're open to suggestions, and I think your suggestion makes a valid point. And I will certainly let General Ford speak about the policies of it. What we were thinking when we drafted this, and the intent was to capture a significant enough deterrence for robocallers. Part of our problem is, of course, catching robocallers to begin with, but we've making significant strides, and you'll see that in the other section that I related to with the Trace Act, that we've had the ability to now work with federal partners, other states, to try to get, and private industry, to try to get tools in place to be able to finally get to the actual source of the robocallers. So I'm certain that General Ford is open to your suggestion, and we can definitely think about ways we could fix that. But we also do, just for the record, want to have something in place that will act as a deterrent, because otherwise it will be difficult to make sure that people stop these horror attacks.
Yeah, and Aaron Ford, for the record, I just want to say you're singing my same song, Assemblywoman Kasama. If anybody knows me, they know that I'm a criminal justice reform advocate and absolutely understand what you talked about relative to the prison overcrowding. In fact, I look forward to working with you using that exact same phraseology on some bills I'm going to have coming before you and others in this particular arena. That said, recognize that we've also put this in as a matter of discussion piece. This is, I guess, the second. I think this was the first draft. All of these are iterative projects, and we look forward to hearing from you on the best way to effectuate criminal justice reform in the context of this issue, and we are open to suggestions that you may have.
Thank you so much for your consideration and for giving me the time. So appreciated.
Okay, next I will go to Vice Chair Carlton.
Thank you, Madam Chair. And this really is a question. So, Attorney General Ford, I think I'd like you to just put on the record the difference between price gouging and what happens with supply and demand. Knowing full well what we experienced over the pandemic and in my private life trying to stock a food pantry, if you'd have told me I was paying $7 to $8 a pound for beef, I'd have said that was unconscionable. But that was supply and demand for the price of beef to be able to put it in the pantry. So I think it would be good for us to just kind of clarify the difference between price gouging and supply and demand.
Absolutely. I'm going to offer some preliminary remarks and have Mr. Kruger talk specifically about the provisions of the bill, because I think the bill itself tries to help outline some of those considerations. It is a question of whether we have supply and demand versus price gouging. We're not talking about something going from $15 to $20 necessarily for toilet tissue. We're talking about $15 to $50, for example, right? And even if it is and that's not likely a supply and demand issue sometimes, it's an issue of people trying to take advantage of, or entities trying to take advantage of folks during tough times. And so the statute lays out, for example, presumptions that will occur. They'll look back 30 days in advance before the pandemic, before the emergency was declared, do a comparison to see if that makes sense. It will inquire into supply chain issues. It will inquire into facts and circumstances to make a determination on whether price gouging has occurred, and because we are in fact sensitive to the law of supply and demand in these issues. And many other states had in place and do have in place, for purposes of emergencies only, price gouging statutes that they could rely upon to protect consumers during this time period. We did not, and it made it a little more difficult for us. And so what we're trying to do is find the best practices from those states to incorporate into our laws to better protect our residents. Mr. Kruger, would you care to offer more detail on the language itself?
Yes, General Ford. Mark Kruger for the record. Madam Vice Chair, I guess the best way to answer this would be to say that there's a carve-out provision in this for supply increases. We recognize that at times, even in times of an emergency, supply prices will increase. And obviously businesses have the ability to increase their costs. If their costs go up, they have to increase what they sell a good for. And that's really the supply increase. What we're trying to get at here is in times of emergency, when you have a fundamental spike in increase that is beyond what the supply chain increase is, that would then trigger the applicability during the time of an emergency of this provision and really what constitutes price gouging. And I hope that answers your question. I would like to note too that I've had a lot of discussions with the industry groups, and a lot of times when we talk about commodities always are subject to federal regulation and as well have their own supply chain increases.
Thank you, General Ford. I just wanted to make sure that we got that on the record. Thank you very much.
Thank you.
Madam Chair.
Thank you, Vice Chair Carlton. I have Assembly Member Artie next.
Thank you, Chair, and it's good to see you, Attorney General Ford. This is a perfect place for the questions that I had in regards to like the penalties as have been discussed. So the way I understand this is, let's say you're in a convenience store or a sandwich shop, and they were charging astronomical prices or what have you. So the way I understand it is like anyone from the clerk to the manager, the owner, whatever, would be subject to these penalties and felonies. So I too kind of think that that's a little extreme. So possibly we can have some discussions around that. But do I understand that correctly? All of those could be subject to those penalties and fines?
I think the answer to that is no. That is no, those levels of individuals will not be held personally liable for that, right? It's the entity that is making the decision for price gouging purposes. And so allow me to, again, however, invite Mr. Kruger in, because if I'm mistaken on that, we absolutely would want to fix that.
Yes, General Ford, you're and Mark Kruger for the record. Generally, you're correct. What we get to here is what the intent is behind the individual. But I think that your point is well taken, and we can work with some language to maybe make it specific. But you generally, what General Ford just said is, generally speaking, you're going to have a decision maker who's going to say, yeah, I'm going to decide that instead of selling a bottle of disinfectant for the normal supply increase of $4, I'm going to sell it for $35. That's the person we're trying to get at, the decision maker.
Okay, I appreciate that. And I just wanted to make sure that is somehow delineated or specified in the legislation. So we're going after, the right people and not penalizing, especially with such harsh penalties, those other people. And then just kind of another little thought along these lines. Could this possibly be extended to say, you have a hotel or motel, rural Nevada or wherever, that is charging again, say their rooms are $50 a night and then they charge $500 a night or something like that. Could this, maybe that's not the intent, but could that possibly be extended to a situation like that?
General Ford, if you don't mind, Mark Kruger for the record, to answer your question. The hotel and motel industry has its own chapter. So we'd have to reach into that chapter to specifically or incorporate that chapter into this provision to specifically capture that group. It was only intended for the goods and services, general goods and services.
I'd like to remind the members to make sure you're requesting a follow-up questions, just because I do have other members who still would like to ask questions.
Okay, Chair. Thank you. I forgot. All right. Thank you for those answers. Appreciate it.
No, you're okay. Thank you. Assembly Member Considine.
Oh, thank you, Chairwoman. I had more of a statement than a question, and it was addressed. Thank you.
Okay, perfect. Thank you. Then I am going to come back to Assembly Member Tolles.
Thank you so much, Chair, for the second indulgence. And if I may, I just want to make a a quick follow-up comment to Assemblywoman Hardy's questions, and then I do have a quick question as well to clarify. So my comment would just be that I too would want to see clarification about who this would apply to. I had that same question, having gotten my start in both retail and restaurants for years. Would appreciate just that clarification of who this would attach to. And I suppose I could ask this as a question, how we would prove that they were knowingly engaged in that activity of making those decisions. Do we have some sort of specific, language that I might have missed here to prove that, a copy of an email or minutes from a meeting or what have you. So I guess that would be my first question, and then I will have another follow-up with the chair's permission.
Mark Kruger for the record, Assemblywoman Tolles. We would do it if it were under a criminal context, we would do it in any fashion that a prosecutor would go, proving either direct or circumstantial evidence or both. In a civil context, we would just apply the standard of knowingly as it's outlined in NRS Chapter 598 and case law to prove it civilly.
Okay.
I'm sorry, we got kicked out. I'm so sorry. We just got back on. So I missed the question. I'm sure Mr. Kruger handled it, but if there was something specific for me, I'm back to answer it. Sorry.
Thank you. Welcome back, Attorney General. And just as a side comment, thank you for, in this and in all cases, being willing to work through these questions and the specifics of these bills. I always appreciate that about you. And so the question that was just asked and answered was in regards to, refining who we're going after and how we prove that they knew. If I may have one last follow-up question, Madam Chair.
Yes, and then we're going to move on to Assemblymember Marzola after your.
Fantastic. So one other question that popped in my mind as I was listening to Assemblywoman Hardy is, because, for example, right now the entire state is in a declared emergency, and we might have, let's say we have tickets on sale at the Raiders Stadium. We start to have just limited amount, socially distanced and what have you, but those tickets are much higher in price. I just want to make sure we don't unwittingly capture areas where, again, back to, I think, Assemblywoman Vice Chair Carlton's questions about the difference between price gouging versus supply and demand. I just want to make sure that we aren't unknowingly capturing some folks in this statute.
Let me offer a thought on that. And again, refer back to Mr. Kruger to the extent he wants to augment this. But, we have separate, per last session, you all put a brand new checkbox on our complaint form that, for example, specifically addresses ticket prices and resales and things of that sort. And so we would have a separate enforcement mechanism, so to speak, that wouldn't have to fall under price gouging, which deals with goods and services, which, for example, back to the hotel scenario, we don't have jurisdiction in real estate issues. And so when people complain to us as BCP on mortgage fraud issues, we have to refer that to the right jurisdictional arena. So we will absolutely ensure that the definition for price gouging is buttoned up such that we don't unwittingly pull within our jurisdiction things that aren't there. But we do have statutory authority on some of the examples that you're providing right now elsewhere. And so, Mr. Kruger, do you want to augment, change, correct anything I've said there?
Mark Kruger for the record, no general report. I think you covered it.
Thank you. Okay, I am going to move on to Assemblymember Marzola.
I'm muted. Thank you, Madam Chair. I have a question on Section 3, subsection 3D. Would that capture gas prices as well?
3D says that a price for good or for a good or service may not be grossly in excess of the usual price for that good or service for the purposes of subsection 1 if that price is generally consistent with seasonal fluctuation or fluctuations in applicable commodity, regional, national, or international markets. Am I reading the question correctly?
You are.
And you want to know would it apply to gas?
Correct.
And the answer to that would be depending upon whether it's defined as a commodity at some level, but also there may be other considerations that are going to kick in here. But it absolutely, deals with national and international markets, to be sure, right? OPEC and the pricing of gas, it seems to me would play into that particular analysis. But Mr. Kruger, do you want to chime in there?
General Ford, Mark Kruger for the record. We didn't have that specific intent in our minds at the time that we drafted this, but I would have to work with LCD Legal to determine exactly whether or not that would cover it or not. So I guess a classic attorney answer is right now it depends.
Thank you.
Sorry.
Thank you, Madam Chair.
Okay. Thank you. And it looks like we have our last question from Assemblymember O'Neill.
Thank you, Chair. I appreciate this. Mr. Attorney General Ford, I appreciate the thought that's going into this. I will be honest, I'm with Ms. Carlton. I had the question on supply versus demand. I could hear my Economic 101 teacher screaming at me. But can we, on section 25, I was looking at this, there's no statute of limitations, if I understand correctly, on deceptive trade practices. Can you help me understand that a little better? I think the only crimes that I know of that have no time limit are basically the child abuse, homicide. This should be something that comes forward, should be known in fairly short time period, shouldn't it?
So a couple of responses, Aaron Ford for the record, and I forgot to say congratulations to the others who've spoken to me. Thank you. Congratulations to you, Mr. O'Neill, for your win again. Let me first reference what you just said about supply and demand. I want to reiterate that there are specific cutouts that address supply and demand, so that if it is an issue of supply and demand, it will not constitute price gouging. So that issue is specifically addressed in verbiage. And I want to go back to Ms. I forget who asked the question. I'm sorry. But the question about gas, it was Ms. Marzola. Congratulations to you, Ms. Marzola, as well. I firmly think that, again, we're going to check with LCB to ensure that our understanding is correct, that gas prices are governed by national and international markets. And that's going to fall within one of the exceptions that we're contemplating here. But we could continue talking about that to ensure. But to your question about the statute of limitations, let me say this. Mark's going to be mad at me, but I agree with you. We do not need to have no statute of limitations on this issue. I've thought long and hard about it, and I am going to, on my own volition, ask if we can.
Well, General Ford,
move that a little bit, but he has a reason for it. So let me let you hear it.
Yeah. General Ford, if I might point out, General Ford and I have spoken about this quite a bit, and Mark Kruger for the record. And one thing that we started talking about, and I thought why I interrupted General is because the final thought that we had come around to in our discussions with also interested stakeholders is perhaps what we could do is have a carve out for the criminal offenses and any private right of action and leave it at the current 4-year statute of limitations. That would resolve your concerns, Assemblyman, and then would allow us to have the Attorney General's office specifically to have the ability to go civilly in our actions that do take a long time and where we find real hidden things. And I'd like to give you a couple examples. Volkswagen emission scandal was one of those cases which took a long time, many years to really reach into and investigate. And if you'll remember, there were a lot of things that were hidden from both federal and state agencies about emissions of these vehicles. Another thing that we are currently litigating, I should say, is certain opioid manufacturers. And if you'll remember, and we've had press releases that go out where, some of these things started in 2016. This is a long time ago. And the no statute of limitations, which is consistent with, we know for sure 13 states that don't have a statute of limitation in this arena allows for a more thorough and broader investigation in an area of very complex litigation with documents that number in ultimately hundreds of thousands that need to be reviewed in order to move forward. So with that in mind, I think General Ford's idea about having a carve out to address your concerns, Assemblyman, makes a lot of sense, and we're willing to work with the industry and yourselves to do that.
And I just reiterate, we always consider these first drafts. And the truth is we have vigorous conversation within this office on the appropriateness of the language that we're pursuing. And sometimes we end up changing our minds. And conversations like this are very helpful in that regard. So please understand that. So thank you for bringing it up, Mr. O'Neill. And we look forward again to working with you to try to address what you've raised.
Thank you, General Ford, and thank you, Mr. Kruger, for that comment. I just had those concerns, and I understand about the length of an investigation. Trust you me, after 40 years in investigations, I understand that. It just didn't seem fair, so I like the idea of that carve-out to go to a civil action. Thank you, Chair, for the time. I appreciate it.
Thank you, Assemblymember O'Neill. Okay, seeing no further questions from the committee, I am going to move to testimony in support. Do I have Bailey Borderland with the Nevada Coalition of Legal Service Providers? Okay, I also have a John McGlamory signed up to provide testimony in support. Do I have John McGlamory on the line?
You do, Madam Chairman. Madam Chairman and committee members, thank you for letting me testify today about this. I am testifying today as a private informed citizen, but my background is that I'm retired from the Nevada Attorney General's Office, Bureau of Consumer Protection, as a senior deputy attorney general, and basically I'm the one who enforced these laws for 17 plus years on behalf of the state of Nevada. And nothing is more frustrating than having a scammer and he's stealing $45,000, $50,000, and all I could do is charge him with the misdemeanor under Nevada deceptive trade laws. It made no sense. So I'm absolutely in favor of all these changes that are in there. But I want to jump over to, I did want to say that I do lecturing for seminars for both AARP and the Nevada Learning Institute at the University of Nevada. So I'm still involved in deceptive trade practice issues. The criminal part, I want to go to the issue of the felony. This is a red herring. It's clear and simple. Judges do not put people convicted for deceptive trade laws, theft, securities violations, put them in jail. They just don't. They'll do it all over. Only had one judge put somebody in jail, and that's the person that had the money to pay restitution and refused to do so over a period of 6 months. They don't put people in jail, but the felony is something that is significant. It goes on their record. There's a lot of other things that go into practice. Not only that, but almost these people, scammers, that's a psychological issue. They are
your time is about up for testimony. If you have something in writing, you can submit it to our committee manager and committee secretary to provide it to the committee members.
Well, thank you. I do have something I got to put in here about small claims court.
Thank you. If you would like to provide your written testimony to the committee, we will make sure to circulate it to the committee members. And also, I will remind everyone, testimony and support means you are in support of the bill as written with no changes. I'm going to go and move to, it looks like I was too quick to jump to the next person to testify. It looks like we do have Ms. Bailey Borderland on the line to testify in support of Assembly Bill 61.
Thank you, Chair. Apologies for my technical difficulties. Bailey Bordelin for the record, representing the Nevada Coalition of Legal Service Providers. We just want to offer support for this bill and say thank you to the Attorney General and his Consumer Protection Office that has been doing some really important work during this pandemic to make sure that consumers are protected at this really important time. And we see a need and understand the reasoning behind strengthening these laws and providing them stronger statutes to enforce the important work that they're doing. So we stand in support. Thank you.
Thank you. And in broadcasting, can we check the telephone line to see if there is anyone who has called in to testify in support of Assembly Bill 61?
Chair, the public line is open and working, but there are no callers at this time.
Thank you. Okay, we will move to testimony in opposition of Assembly Bill 61. I do have a few people signed up to give testimony on video, so I will start with Peter Guzman with the Latin Chamber of Commerce. Mr. Guzman, are you on?
I am. Thank you so much, Madam Chairwoman, for allowing me to give testimony. I want to compliment everyone who's asked, all the electors who've asked incredible questions that have led me to even more questions. I know I won't have time for them. The Latin Chamber supports the general spirit and concept of punishing bad actors and certainly would never question Attorney General Ford's good intentions. He's always fighting for the minorities. But at this time, we cannot support this bill as currently written. Yesterday, our government relations team had a very productive call with the Attorney General's office, and we are committed to continuing to work with the AG's office to address our concerns. Our current concerns with the bill include the following. It potentially creates a business trap for small businesses, a trap which could provide for endless litigation with no reasonable parameters on the statute of limitation, which in turn could stifle business growth and job creation. Second, enhanced criminal penalties and fines, which could lead to unintended prosecutions and incarcerations, which doesn't seem consistent with the current environment of criminal justice reform measures. As written, the bill applies to all persons and businesses engaged in the selling of or renting of certain goods and services, and all such persons and businesses, to include store clerks, managers, and owners, could now be prosecuted under felony statutes rather than misdemeanors. I think that's excessive. I also wanted to say in closing, I'm really now concerned with we must clearly identify what businesses can and cannot be prosecuted on this. We all know that hospitality service industry raises their room rates during big conventions, and they raise them high. And so would they be penalized? Could they be felons? No. And the gas and the beef. So I think we clearly need to do a little more identifying specifically so that we don't have unintended consequences. I appreciate you allowing me to speak today.
Absolutely. And looks like you were reading your testimony. So if you'd like to provide it to our committee secretary to share it with the committee, please do. Next, we have Kendra Bertsky with the Washoe County Public Defender's Office.
Good afternoon. Thank you so much for allowing me to testify today. First, I would like to thank the Attorney General's Office for their intentions with this bill to protect our citizens. We were able to speak with Chief Deputy Attorney General Kruger yesterday to express some of our concerns with this bill. We look forward to continuing to work with him in order to address our concerns. I want to start by, again, thanking Attorney General Ford for his efforts and advocacy with the criminal justice reform system last session, as well as his continued efforts this session. We do have concerns with raising the criminal penalty on robocalls from a misdemeanor to a Category C felony, increasing as well as creating new crimes. I would just note that restitution can be requested and ordered in misdemeanor cases. And we do look forward to continuing to work with the Attorney General's Office to strike the balancing between protecting consumers and deterring criminal conduct. The U.S. Department of Justice has published scientific evidence. What they found that the certainty of being caught is vastly more powerful deterrent than punishment. Increasing the severity of punishment is ineffective in deterring crime. We also noted, and I believe that Assemblywoman Tolles discussed some of our concerns regarding overbroad language, which we believe may capture individuals that this bill doesn't intend to capture. And with that, I know that Mr. Piro will provide remarks, and we agree with his remarks as well.
Thank you, Ms. Birchke. Next, we have Paul Moradkin with the Vegas Chamber.
Good afternoon, Chair Howdiggy. For the record, Paul Moradkin with the Vegas Chamber. I would like to thank the Attorney General's office for their time as we were working through some of our issues yesterday and appreciate their engagement with the business community. As we work to address some of our technical concerns with the bill, as you heard, there's some concerns with sections 3, 4, 5, and 19 are just a few of those, and our concern about unintended consequences. It is our hope, of course, that we'll be able to come to a resolution on this bill and remove our opposition, as of course the Chamber does not support fraud or related activities. So thank you, Chair, for your time today. Appreciate it.
Thank you, Mr. Moradkin. We will then move to John Piro with the Clark County Defender's Office.
Thank you, Madam Chairwoman. John Piro from the Clark County Public Defender's Office. I want to echo the comments of Ms. Birchke and Mr. Guzman that came before me. I'm going to focus my comments on sections 25, 26, and 28 through 30. Deleting the statute of limitations seems like a small change, but it's actually a huge change. Long delays impair the ability of an accused to defend themselves. For example, a long delay will affect an accused's ability to confer with potential witnesses, keep track of witness whereabouts, and will impair the accused's ability to prepare a defense and investigate allegations. Because the passage of time erodes memories, witnesses disappear, and events lose context over time. The bill as written would remove the statute of limitations for deceptive trade practices. The only other statutes on the book that do that right now are murder and terrorism. So it would elevate deceptive trade practices to the level of murder and terrorism and totally throw our statute of limitations scheme out of whack. Defending this charge decades after the fact would be incredibly burdensome and costly. So at this point, we are in opposition, but would like to thank the Attorney General's office for speaking with us about our concerns and Mr. Kruger for talking with us and being open to keep working on this bill. We hope to move out of opposition. We do not want to stop the AG's office from going after bad actors, but we do need to narrowly tailor some portions of this bill so that we capture the right people for the right reasons and keep integrity in the criminal justice system. Thank you.
Thank you, Mr. Piro. Thank you. Next, we have Nick Vanderpool with Capital Partners.
Good afternoon, Madam Chair, members of the committee. For the record, Nick Vanderpool with Capital Partners representing the Reno-Sparks Chamber of Commerce. The Reno-Sparks Chamber of Commerce is opposed to deceptive trade practice by its very definition, but not supportive of excessive and costly litigation that is outlined in this proposed legislation. And for that reason, we must oppose Assembly Bill 61 in its current written form. But it must be noted that we did speak to the Attorney General's office, and we do appreciate that conversation. With that being said, we did commit to work with the Attorney General's office, but as written, must oppose. We look forward to further conversations, and thank you for your time.
Thank you, Mr. Vanderpool. Last, I have Brian Wachter with the Retail Association of Nevada.
Thank you, Madam Chair. Brian Wachter with Retail Association of Nevada. We too have had conversations with the Attorney General's office yesterday, Mr. Kruger, and we look forward to working with them as this bill moves through the process. I wish I had more time to outline and explain to you the amount of changes and the drastic issues that the supply chain has gone through, and we really appreciate Vice Chair Carlton mentioning that the supply chain really went through a lot of challenges in the last 11 months. We can recall how empty our grocery store shelves were, especially at the beginning of the pandemic. And I think that gives further credibility to the fact that price gouging was not rampant or widespread. If that were the case, there would have been products on the shelves. I think also another case that gives validity to the fact that this wasn't a widespread problem is that the Attorney General mentioned that they had received dozens of complaints over the last 11 months. And we've got 3 million residents and we have many million more visitors that visit us every year. I think a dozen is certainly worth exploring, and we'd be interested to know how many of those were actually found to be valid cases of price gouging. The Attorney General also mentioned that this wasn't designed to prevent price increases that go from $15 to $20, but the bill would actually put a limit on a $15 item can only go up to $16.50. The way the bill is currently written before you start getting into the period of having a deceptive trade practice. So we would agree in general that it is very overly broad. We would draw your attention to sections 3.1a. We think this section is very broad and would actually be covered in 3.1d. We have concerns with section 3 sub 4. We also have concerns about section 3 sub 5b and really outlining who this would apply to and who would be subject to those actions. Section 4, we really question whether this would be a deterrent. It's already illegal under federal law. And so we question the need to make it and define it as a deceptive trade practice, even though it's already illegal under federal law. We also have concerns with section 7.1e and 7.2b. We think those are overly broad.
We appreciate you joining us today and giving your testimony in opposition. And Mr. Wachter, if you do have your testimony, and for all of those who were testifying, if you do have anything in writing, I would encourage you to provide it to our committee manager or secretary so that they could share it with the committee members. Broadcasting, can we please turn to the telephone line to see if there is anyone signed up to testify in opposition?
Testify in opposition on AB 61. Please press star 9 now to take your place in the queue. Caller with the last 3 digits of 080, please slowly state and spell your name for the record. You'll have 2 minutes and may begin now.
Hi, Jim Hoffman for the record, Nevada Attorneys for Criminal Justice. I would echo what Ms. Birchie, Mr. Pirro, and Mr. Shepak said. The additional point I would make is that we have this problem with mass incarceration in both Nevada and the country. And one of the main causes for that is that people pass criminal laws that make sense at the time. They respond to a real social problem at the time, but then they stay on the books forever. They mutate, they're extended to new things that the drafters of the law didn't consider. And we think this is a situation where that might happen. Mr. Ford said that he has credibility with criminal justice advocates, and it's true, he does. But he's not going to be Attorney General forever. And I think the committee should consider how this broad delegation of power might be misused, decades down the line. So again, we look forward to working to resolve some of these issues, but for now we oppose. Thank you.
Thank you.
Chair, there are no more callers in opposition at this time.
Thank you, Broadcasting. I will now move into testimony in neutral. Do I have Paul Enos with the Nevada Trucking Association on the line? Broadcasting, could we check the telephone line to see if there's anyone signed up to testify in neutral?
To testify in neutral on AB 61, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 584, please slowly state and spell your name for the record. You have 2 minutes and may begin now. Again, caller with the last 3 digits of 584. You could please slowly state and spell your name for the record. You have 2 minutes and may begin.
Thank you, Madam Chair and members of the committee. My name is Jennifer Richards, JenniferRichards. Can you hear me?
Yes, we can.
Thank you. I hold the office of the Attorney for the Rights of Older Persons and Persons with a Physical Disability. under NRS 427A and serve at the pleasure of the governor. This office works to advance systematic improvement throughout the Aging and Disability Services Network through legal advocacy and policy advocacy so that all Nevadans can live independent, meaningful, and dignified lives. In addition, the office acts as the designated legal assistance developer under the Older Americans Act. The COVID-19 pandemic has disproportionately affected older adults and persons with disabilities. As the legal assistance developer for the state of Nevada, I can report anecdotally that our legal aid grantees have experienced a significant increase in consumer protection cases across the state, which we have been referring to the Nevada Attorney General's office. In addition, the Federal Trade Commission is currently reporting that upwards of $340 million in total fraud loss has occurred due to the global pandemic. The FTC reports that persons over 60 experience these losses at higher rates than other ages. Specifically, persons over 70 experience a higher loss than all other ages. The FTC reports that there has been a 2,000 plus increase in identity theft reports regarding government benefits applied to or received. While fraud affects every generation differently, for persons over 70, the preferred contact method to perpetuate fraud is via telephone. This is a very important issue and is affecting the population that the Aging Disability Services Division serves. And we want to thank the committee and the Nevada Attorney General's office for addressing it this afternoon.
Thank you, caller. And if you have testimony that you'd like to submit, and for everyone who is listening, you can provide it to our committee manager at asmcl@asm.state.nv.us. Broadcasting, do we have anyone else on the line to testify in neutral?
Chair, there are no more callers in neutral at this time.
Okay, thank you.
Chair Hobby.
Ford, are you with us? Would you like to give any closing remarks?
I would. Thank you so much. And again, we look forward to working with those who called in. As they all testified, most of them talked to us yesterday about the concerns they have with the bill. So clearly we haven't had an opportunity to digest or interact with them in detail, but we look forward to having those conversations. And some of the concerns raised, we've already acquiesced to. For example, the criminal concern, we absolutely will be addressing that. So Fred Knott, Mr. Pirro, and others on that particular issue. And let me be clear. I said dozens of complaints, and I may be underestimating. Let's be clear about this. My office received, we were overrun with complaints during the COVID season. Some related to price gouging, some related to evictions, and I can't even count. And I didn't want to offer a number because I didn't want to be wrong on it. But let's be clear. We got many, a whole bunch, more than just 12 price gouging complaints. And you didn't have to look at my phone records to see the complaints. Look on Facebook, look on Twitter, look elsewhere. You saw this going on in our communities, and those who reached out to us, we tried to address. Our statutes were woefully insufficient to prosecute, to directly address what Mr. Walker has indicated. A lot of these instances. And fortunately, we were able to have conversations with some to convince them to back off of what we saw was clearly an opportunity and an intent to take advantage of the purchasing public. So don't let the number that I say out loud fool you. We have a problem here in price gouging when it comes to emergency circumstances. I think everybody saw it, and we intend to try to continue working on it. Mark Kruger is great. He's fantastic. He's going to be my point person on the negotiation for the rest of this particular bill. Again, we look forward to receiving whatever concerns that people have, and we will endeavor to accommodate them. We will compromise what we can and disagree what we must, but we look forward to working with those who have an interest in this bill. So thank you so much, Chair Howdiggy. I appreciate the opportunity to address you today.
Thank you, General Ford. I will now close the hearing on Assembly Bill 61. The next item on our agenda is Assembly Bill 155, and I believe we have Assembly Member Michelle Gorlow here to present along with Jennifer Pierce. Assemblymember Gorlow, are you with us?
Yes, I'm here.
Welcome to the Committee on Commerce and Labor. I will now open the hearing on Assembly Bill 155, and you can proceed when you're ready.
Well, thank you very much, and good afternoon, Chair Howdiggy and members of the Commerce and Labor Committee. My name is Michelle Gorlow, and I represent Assembly District 35. I appreciate the opportunity to present AB 155, which increases maximum fee caps for licensing and other services provided by the Speech Language Pathology, Audiology, and Hearing Aid Dispensing Board. It is a mouthful, so we'll be referring to it as a Speech and Hearing Board from here on out. I'm joined today by the board's Executive Director, Jennifer Pierce, who will be co-presenting with me on today's bill. During this time of great financial difficulty for many Nevadans, it does seem a little counterintuitive to pursue higher licensing and renewal fees. However, the proposed cap increases are necessary to alleviate solvency concerns by replenishing the board's reserve fund. Since 2018, the Speech and Hearing Board has invested in several technology updates for their licensing database to fully integrate with their website and online application process. The additional costs associated with licensee growth, uncompensated investigations, and legal work has resulted in continual spending deficits. In fact, the board has reported a net negative income from 2016 to 2019. The Speech and Hearing Board's reserve fund have been vital in covering these operational and modernization costs, but the cumulative deficit over the last few years puts the adequacy of the fund in jeopardy. The fee cap increases before you today will allow the board to undertake a public process to implement a modest fee increase that is necessary to solve the budgetary concerns of the board, which as an independent entity is funded solely through licensing and service fees. We would not pursue this course of action if the bill's financial impact were overly burdensome on practitioners in the field. As Ms. Pierce can articulate, the current structure of the board fees relative to median wages in the field show the board's fees are modest and affordable when compared to similar professions. For example, the median salary of speech hearing practitioners is ranked highest among professionals in 18 board comparisons, while the fee cap for new licensees ranked 14 among the same group. Any fee increase implemented would only marginally impact professionals in the field. So I will now turn it over to Executive Ms. Jennifer Pierce, who will further discuss the board's intent and new fee schedule and financial impact of AB 155.
Thank you, Assemblywoman Gorlow. This is, for the record, my name is Jennifer Pierce, Jennifer-Pierce. I'm the Executive Director of the Nevada Speech Language Pathology, Audiology, and Hearing Aid Dispensing Board. And I had a brief PowerPoint slideshow that I wanted to share as I make my remarks today, if that's all right. Good afternoon, Chair Howdege and members of the Commerce and Labor Committee. Thank you so much for the opportunity to present on AB 155. As Assemblywoman Gorlow explained, our practice law, NRS 637B, prescribes the maximum fees the board may charge for licensing and other services by setting fee caps. This bill would increase 5 of our 8 fee caps in the NRS, and the board's intent in pursuing this bill is to support its continued work on behalf of licensees, the public, and the state. We recognize that this is not an ideal time to raise fee caps. This initiative was approved by the board in January 2020 and quickly and thoughtfully revised in the wake of the pandemic. All of the fee cap increases proposed in the bill are lower than originally planned, and some were eliminated altogether. The board's budget has resulted in a deficit in the last 4 fiscal years, and in most years, the deficit budget was developed strategically to allow us to invest in technology and support services that increase staff efficiency and benefits to licensees, such as online applications, renewals, and payments. Right now, the board's reserves equal approximately 1/3 of our annual operating costs. Currently, all actual fees charged are at the maximum fee cap except for just one. An increase in fee caps creates room for a modest increase in actual fees charged, which is critical to replenish reserves. One of the board's most important charges is our role to protect the public. With growth comes the opportunity for more complaint and disciplinary cases, which can be costly to the board in legal and investigative fees, which are necessary, often substantial, and frequently irrecoverable. Finally, our work relies heavily on investments in technology and efficiency. As such, we have made several investments since 2017 in a licensing database and integrated website to improve licensee access to applications and renewals. Online renewal and payments have been available to our licensees since 2017, and online applications went live in October 2020. Our licensing process is extremely efficient as we are able to issue licenses within 3 to 5 business days of receipt of a complete application. I would also like to share with you briefly the diligence with which we have undertaken cost-saving efforts. The board employs 3 part-time staff, myself, the ED at 2/3 time, a half-time licensing coordinator, and an investigator used on an hourly as-needed basis. Staff have forgone salary increases this fiscal year, and with the implementation of online applications, we do not anticipate the need to increase staff hours. The board shares office space with the occupational therapy and environmental health specialist boards to reduce costs, and we have relinquished unneeded office space to lower those costs going forward. In early 2020, the board integrated our website with our licensing database vendor, and this revision has already reaped significant benefits and maintenance cost savings, reducing the need to pay hourly IT support costs. At the end of 2019, we transitioned our board email to Office 365 and began using SharePoint to store board documents, which has been especially useful as we began working remotely due to COVID-19 and will mitigate future storage costs. And while we cannot predict the number and nature of complaints received, it is hoped that future efforts towards licensee education on our practice laws and regulations may result in fewer complaints. Again, we too are concerned about the economic well-being of our licensees, and it is not the board's intent to pursue excessive fee increases, rather an effort to practice fiscal responsibility. A $25 increase to new application and renewal fees would provide the board with enough surplus to break even in most future years and slowly rebuild reserves. We would like to emphasize to the committee, our licensees, and stakeholders that an increase to actual fees charged would be made to NAC through the administrative rulemaking process during the 2021-2022 interim, which would include very careful consideration by the board and ample opportunity for input from licensees and the public. We have made every effort to keep licensees and the Nevada Speech Hearing Association apprised of this initiative through regular email communication and website updates, both of which have included the resource materials submitted for today's meeting. We are grateful for this partnership with the association and look forward to future work together on behalf of our licensees. This final slide illustrates the requested increases to the fee caps. The board declined to request a raise on fee caps for hearing aid dispensing examinations and the conversion and endorsement fees that a licensee pays in addition to a regular license or renewal fee. Again, the board does not intend to utilize the entire fee cap increase when considering an increase to actual fees, and is committed to being a responsible steward of the fees it collects. Thank you for your time today, and I'm happy to answer any questions you may have.
Thank you, Assemblymember Garlow and Ms. Pierce. I'm going to turn to the committee to see if anyone has any questions. Committee members, any questions? Assemblymember Tolles?
Yes, thank you so much, Chair, and I really appreciate your presentation. Thanks for addressing certainly our concerns about raising fees in the midst of this current situation that we're in, and also explaining this isn't necessarily an automatic raise of fees. It's just a raising of the caps so that you could work through that process. And I do appreciate that you've solicited input from your members, or let them know that you would solicit that from them through the process. I guess my question is, have you, before today's proposal, surveyed your members, and do you have any kind of survey results as of today about whether or not they are in favor of this request?
Yes, thank you. For the record, this is Jennifer Pierce. Thank you, Assemblywoman Tolles. We did. We conducted a licensee survey in June of 2020. We got sort of moderate response, so there were quite a few neutral, but I would say about half of the responses were either opposed or strongly opposed, which we expected. We also know that, the pandemic has affected everybody, and so we knew that, that would be an expected response. So that survey did indicate that to us, but I have not gotten very many specific responses when I have sent out emails or anything posted on the website.
Follow-up, Chair?
Yes, please.
Thank you. So just to make sure I heard you clearly, you said about half were opposed or strongly opposed. Many were neutral. I didn't hear, were there any that were in favor? That's of course one thing I don't know that I have in front of me. There were comments that I can recall where there was at least one comment. I remember somebody making the comment, the board needs to do what the board needs to do for its budget. I cannot recall off the top of my head, but I can look while we're speaking to see if I can pull up the surveys.
survey responses on that item.
And Chair, per your indulgence, I'm certainly happy to have that follow up afterwards with the whole committee so we don't take up too much time.
Yes, Ms. Pierce, any follow up, you can provide it to the committee manager and she'll disperse it to the entire committee.
Thank you.
Assembly Member O'Neill.
Thank you, Chair. Quick question. When were your fees last set?
Thank you, Assemblyman O'Neill. Our fee caps were last changed in 2015 when the board.
Ms. Pierce, if you would just a quick reminder to just identify yourself before speaking. It just makes it easier for our committee secretary to take.
My apologies. Yes, for the record, Jennifer Pierce, Nevada Speech Hearing Board. Assemblyman O'Neill, our fee caps were last raised in 2015. Our current board is a merger of the formerly separate speech and language pathology and audiology and then hearing aid dispensers boards. So those two boards were merged in the 2015 session and the fee caps were raised then. And then I believe there was a change to the actual fees in that following interim.
Thank you, Ms. Pierce. Thank you, Chair.
Assembly members, any further questions? Okay, seeing none, we are going to go ahead and move to testimony in support of Assembly Bill 155. Do we have a Sarah Adler with us with the board?
Good afternoon, Madam Chair and members of the committee. I simply want to follow up to Assemblywoman Toll's question and let her know repeated notifications through email have been sent to all of the licensees since the BDR language was published and the bill number was published, and we let them know of the hearing today. That was on Friday, and Ms. Pierce only received one email back, and that was, "You've been doing a good job, and good luck." So a lot of outreach, and that was our most recent response. In addition, we held a meeting with the Speech Hearing Association on Monday night, an impromptu meeting, because this was a quickly scheduled hearing, which we very much appreciate. And we had very positive dialogue with the association. So thank you. I'd like to share that information.
Ms. Adler, this was for testimony and support, correct?
Yes.
Okay, thank you. Broadcasting, can we please check the telephone lines to see if anyone has called in to testify in support?
To testify in support of AB 155, please press *9 now to take your place in the queue. Chair, there are no callers in support at this time.
Thank you, Broadcasting. Will you check the telephone line to see if there is anyone who is wishing to testify in opposition?
To testify in opposition on AB 155, please press *9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Okay, thank you. Can we check the line to see if there is anyone wishing to testify in neutral?
To testify in neutral on AB 155, please press *9 now to take your place in the queue. Chair, there are no callers in neutral at this time.
Okay, thank you. Assemblymember Gorla, would you like to give any closing remarks?
Thank you, Chair Hadeke. I just wanted to mention just real quick that there is an exhibit on Nellis that is a letter in support. Hadn't had a chance to read it. There is a letter on Nellis. And other than that, I'll see everybody in the hallways and answer any questions they may have. Thank you.
Thank you, Assembly Member. I will now close the hearing on Assembly Bill 155. And this brings us to our last agenda item, which is public comment. While I give callers or those watching over the internet time to call in, I am going to read some quick housekeeping when it comes to public comment. I would like to remind those present that the period of public comment is an opportunity to discuss general matters that fall within the purview of this committee. The public has already been given time to support or oppose specific legislation. We open and close hearings on bills so that we establish a record of the public testimony on a bill. Therefore, public comment is not intended to be a continuation of a bill hearing. We take 30 minutes of public comment, and public comment may be limited to 2 minutes per caller. Broadcasting, can we check the telephone line to see if anybody has joined us or is waiting to give public comment?
To take your place in public comment, please press *9 now to join the queue. Chair, the public line is open and working. However, there are no callers at this time.
Thank you. Committee members, I know the agenda has not posted, but we will be meeting on Friday, and please note the start time of the agenda. We will be meeting at noon or upon the adjournment of floor. Thank you, and that concludes our meeting for today. We are adjourned.